Page 19. A 1993 New York custody ruling. Signed by Justice Elliot Wilk. Public record. Still available today. Most people have never read it. The sentence almost nobody quotes is this: Woody Allen's behavior toward 7-year-old Dylan Farrow was grossly inappropriate, and measures must be taken to protect her. A sitting judge wrote that. Not Mia Farrow. Not a tabloid. A judge, after 7 weeks of sworn testimony in a binding legal ruling that has never been overturned. The public story says Woody Allen was never charged, never convicted. Cleared. That page 19 says something different. The story of Mia Farrow, what Frank Sinatra really did, what Woody Allen's own court file actually contains, has been sitting in 30 years of public documents. Nobody read them. We did. And what they say is not what you were told. July 19, 1966. The Sands Hotel, Las Vegas. Not a grand ceremony. 5 minutes. A civil proceeding held inside the private residence of the hotel's president, Jack and Tratter, with a handful of witnesses present. The bride, Mia Farrow, 21 years old. Daughter of film director John Farrow and actress Maureen O'Sullivan, the woman who played Jane opposite Johnny Weissmuller's Tarzan for an entire generation of moviegoers. Mia had been working since she was a teenager, already known to primetime television audiences from 3 seasons on Peyton Place. She was not an unknown ingenue stumbling into fame through a famous man's doorway. She was already, by 21, a working professional with a career of her own. The groom, Frank Sinatra, 50 years old, the most recognized voice in the world. The press ran it as a fairy tale with an asterisk, obsessed, predictably, with the 30-year age gap. Sinatra's ex-wife Ava Gardner was widely quoted making a joke about it. The short tint that settled over the marriage, and calcified for 6 decades afterward, was simple: an aging legend, an elfin young actress, a whirlwind romance that collapsed the way whirlwind romances do. A 9-carat diamond. A honeymoon. A quiet, inevitable ending. Farrow herself has described how sudden it was. Sinatra called the day before, she has recalled, and said they were marrying the next morning. No time to find a dress. She wore whatever was already in her closet. None of that is inaccurate. It is, however, incomplete. The piece that matters, the piece that rewrites the entire story, is not how the marriage began. It is how it ended. Specifically, who walked away. And from what? By 1980, Mia Farrow's public story had reorganized itself around a different man. Woody Allen, already the writer and director behind Annie Hall, which had won 4 Academy Awards in 1978, became her partner. The relationship would last 12 years, produce 1 biological child together, and generate more than a dozen films. Farrow appeared in 13 of Allen's films across the 1980s, Zelig, Broadway Danny Rose, The Purple Rose of Cairo, Hannah and Her Sisters, for which she received a Golden Globe nomination, Radio Days, Crimes and Misdemeanors. Allen's own interviews from the period described her presence on screen as essential to his filmmaking process, a creative dependency he returned to, in print, repeatedly. Magazine profiles of the couple settled on the word muse so consistently that it stopped sounding like a compliment and started sounding like a job description. What those profiles didn't cover, what almost no coverage from that decade covered, was the household running behind those films. Farrow was raising an enormous family, almost entirely out of frame. Eventually more than a dozen children, biological and adopted, including children with significant disabilities, children adopted from South Korea, Vietnam, and India. The logistics of that household, the daily labor of it, the medical appointments and the school runs and the emotional weight of raising children who had come into the world through trauma, none of that made the cultural profiles of Woody Allen's muse. After the partnership ended, Farrow would spend years as a UNICEF Goodwill ambassador, traveling to conflict zones across sub-Saharan Africa, Chad, the Central African Republic, Darfur, documenting conditions in refugee camps and advocating in front of the United Nations Security Council. She went to places most people with her degree of public recognition actively avoided. That work, the work she did in the years when the Allen scandal had made her professionally radioactive in Hollywood, gets almost no airtime in the retrospectives that reduce her to a footnote in two other men's stories. It is, arguably, the most substantial thing she has done with her adult life. It is almost never the first thing anyone mentions. This was the second chapter the public accepted, a stable, prestigious creative partnership between two serious New York artists, building films and a family side by side while the rest of the industry collapsed around them in divorces and scandals. That story held for 12 years, until January 1992. Until a mantelpiece. The discovery was photographs, Polaroids, left where Farrow would find them. They were images of Suni Pravin, one of the daughters Farrow had adopted during her earlier marriage to conductor Andre Pravin. Suni was 21 years old. Woody Allen, 56, had been involved with her. What the tabloids built from that discovery was not a story. It was a frame. And the frame had a name everybody recognized, The Scorned Woman. Allen gave Time magazine the line that would define him and that fall and that decade. The relationship made sense to him, he said, because, in his exact words, the heart wants what it wants. That phrase traveled immediately and widely. U.S. Attorney General William Barr invoked it on the campaign trail as shorthand for moral failure. Newt Gingrich used a version of the affair in a speech in Georgia as a family values talking point. Allen's studio moved the theatrical release of Husbands and Wives, a film starring Allen and Farrow as a couple in the process of disintegrating, from a limited 8-city run to a full national rollout within weeks of the real-life collapse becoming public. Critics remarked, with varying degrees of discomfort, on the closeness between the fiction and the fact. Then, in August 1992, came the allegation that would outlast every other element of this story. Dylan Farrow, 7 years old, told her mother that Woody Allen had sexually abused her. In the attic of the family's Connecticut home. Allen's explanation arrived immediately, and it never changed across the 30-plus years that followed. Mia Farrow had manufactured or encouraged the allegation. Revenge. Fabrication. The oldest frame in the catalog, a woman, betrayed, inventing the worst accusation she could reach for. It made intuitive sense to a lot of people in 1992. Clean, legible, familiar enough to settle without much inspection. What nobody outside the courtroom had, what the tabloids of that summer didn't have and didn't print, was the documented sequence of how the allegation actually began. I went back and read the wire copy from that week. The actual wire copy. The Attorney General of the United States was on a campaign stage, making a joke out of a celebrity affair, while an 8-year-old's medical examination was happening 2 states away. Dylan Farrow wasn't mentioned. Not once. She was punctuation at the end of someone else's punchline. I thought about that a lot while making this. It's easy to feel superior to 1992 from here, to tell yourself the coverage would be handled better now. I'm not convinced it would be. Here is what the 1966 wedding headlines never followed up on. By autumn of 1967, Mia Farrow was filming Rosemary's Baby in New York. Director Roman Polanski. The shoot ran behind schedule. Sinatra, by Farrow's own account in interviews given decades later, wanted her off the production. She has recalled him telling her directly he was taking his girl out of it. She refused. She's explained her reasoning in multiple interviews. She was the daughter of a film director and a working actress. Walking off a production in mid-shoot, with 1 month of filming remaining, with her appearing in nearly every scene, was not something she would do. Not for anyone. Not even for a husband. Sinatra did not come to the set himself. His lawyer did. Divorce papers were served on set, in front of the cast and crew, while Farrow was still in costume. She has said, in her own words, that she had been certain it wouldn't actually happen until the lawyer arrived, and it did. The marriage that had begun with a 5-minute ceremony at the Sands Hotel ended on a New York soundstage, delivered by an attorney standing in for a husband who didn't appear. Sinatra would resurface in this story one more time, decades later, on the other side of the Woody Allen scandal. Multiple biographers have reported, with enough consistency across enough separate sources to be something more than rumor, though it was never tested in any court, that Sinatra offered, when the SUNY photographs became public in 1992, to have people he knew address Allen physically. Farrow has never confirmed acting on the offer. Nothing came of it, but the detail is worth holding for a moment. The man who once dispatched a lawyer to end a marriage was, 30 years later, still positioned in Mia Farrow's life as someone who showed up when she needed someone to show up, even when the showing up was only an offer, and the offer went nowhere. The public story frames Sinatra as the established man who generously took on a much younger wife. The documented ending of that marriage complicates that framing completely. The young wife wasn't the one who walked. She held her position on a film set and finished her work. She was handed divorce papers for it. August 1992. The allegation begins here, in the documented record, and the documented record begins somewhere other than Mia Farrow. The public version of this story, the one that held for decades, cast Farrow as the originating force, a humiliated woman manufacturing the worst accusation available and driving it through a compliant system. That version has a problem. It doesn't match the sequence of events on file. According to the custody court record, Dylan described what she said had happened to a Connecticut pediatrician, Dr. V. Havarajan. Under Connecticut law at that time, a treating physician who receives a child's account of possible abuse is legally required to report it. That obligation is statutory. It is not discretionary. It does not require the parent in the room to agree, or to initiate, or to want the call made. Dr. Havarajan made the report to the Connecticut State Police. That mandatory report is what triggered the official investigation, including the referral to the child sexual abuse clinic at Yale New Haven Hospital, which would become one of the most contested documents in the case. From that single statutory report, the matter divided into 3 simultaneous tracks: a Connecticut criminal investigation, the custody litigation in New York's Supreme Court, and a review by New York's Department of Social Services. Each track ran independently. Each produced a different finding. The Department of Social Services concluded there was insufficient credible evidence to support the allegation. The custody court reached more complicated conclusions. The criminal track produced a prosecutor's statement that would sit uneasily in the public record for decades, quoted by almost nobody, read by almost nobody, sitting in exactly the place this kind of evidence always ends up, available to anyone willing to look, ignored by almost everyone who formed an opinion. 3 tracks, 3 institutions, 3 findings that would not align. None of this establishes what happened inside that Connecticut house. What it does establish is that the chain of events documented in the public record begins with a legally required report from a treating physician, not with a phone call from a furious mother to a tabloid desk. Here is a document that does not help Woody Allen's side of this story. It also does not help Mia Farrow's. In 1990, 2 years before the allegation, 2 years before the photographs on the mantelpiece, Farrow amended her will. The amendment specified that in the event of her death, Allen would receive custody of their 3 children together, Dylan, Satchel, and Moses. She put that in writing, signed it, and filed it. The following year, 1991, she went further. She signed a sworn affidavit in support of Allen's legal adoption of 2 of those children, Dylan and Moses, describing him in that document as a loving and attentive parent. That affidavit is in the court record. Dated months before the Polaroids. Months before the allegation. Signed and sworn. Alongside it, In the same trial, Farrow gave testimony describing Allen's behavior toward Dillon as relentless and overpowering, with what she characterized as a wooing quality she found troubling. She testified separately that she had confided to her own therapist a fear that Allen's fixation might eventually extend to their son, Satchel. Two sworn documents. Two opposite pictures of the same man, the same child, the same relationship. Both entered into evidence. Both filed in the same proceeding. A will and an adoption affidavit don't capture a person's private doubts the way a diary might. They capture what a person was willing to commit to in writing for a specific legal purpose at a specific moment in time. Neither of them was written for the trial that came after. That gap between what was written then and what was testified later is the kind of thing that no amount of subsequent explanation fully resolves, not for Farrow's credibility, and not for Allen's argument that her account was purely invented from nothing. The version of events that circulated most widely in 1992 treated the allegation as resting on a single foundation, the word of a 7-year-old child, relayed entirely through her mother. One voice. One source. Easily dismissed as tainted. The trial transcript holds other voices. Allison Strickland was employed as a nanny by Casey Pascal, a close friend of Farrow's who was also present in the Connecticut house that August. Strickland testified under oath in New York Supreme Court that on the day in question she approached a doorway in the house and observed Allen kneeling in front of Dillon, his head in her lap, in a position she found sufficiently concerning to report. She said she reported it to Pascal immediately, and Pascal brought it to Farrow. Moses Farrow has challenged this account in detail in his later public statements, asking specifically why, if Strickland witnessed what she described, she did not immediately tell the other nanny present that day, Christy Grote. Grote's own account of the period introduced a separate, noted detail, that she had observed Dillon was not wearing underwear that afternoon. 3 household staff members. 3 accounts. They don't align on sequence. They don't align on significance. What they do collectively establish is that the allegation did not begin and end with one mother and one child, filtered through no other witness. There were other adults in that house who said, under oath, that they saw and heard things of their own. A 4th voice completes this section. Susan Coates was the family's therapist, a clinician who had observed Allen and Dillon together directly, over time, long before any allegation existed. Coates testified that she had witnessed some of the behavior herself. She did not characterize it as sexual. She described it, in her own language entered into the record, as inappropriately intense because it excluded everybody else. A professional assessment, formed before the scandal, landing in territory the news coverage never mapped, not abuse, by her reading. And not, by her reading, nothing. This is the document at the center of everything, and the one every summary version of this story skips past. After 7 weeks of testimony, Justice Elliot Wilk issued his ruling on June 7, 1993. He denied Allen custody of all 3 children. He called Allen's custody petition frivolous. He ordered Allen to pay Farrow's legal costs. In his written findings, he described Allen as self-absorbed, untrustworthy and insensitive. On the specific question of abuse, Wilk's language was precise and bounded. He wrote that the evidence did not support a finding that abuse had occurred, but he declined, with equal care, to find that it had not. He left that question open. What he did not leave open was his assessment of Allen's conduct toward Dillon. He wrote that it had been grossly inappropriate, and that protective measures must be taken. He noted separately that he did not consider that behavior sexual in nature. Then he turned to the evidence Allen's team had relied on most heavily, the report produced by the Child Sexual Abuse Clinic at Yale New Haven Hospital, which had concluded that Allen had not abused Dillon and that Dillon may have been influenced by her mother's state of mind into producing an account that wasn't accurate. Wilk examined how that report had been produced. The clinic's team had interviewed Allen, Farrow, Dillon, and household staff over months. But its lead clinician testified only through a written deposition, never appearing in open court. And the clinical notes from those months of interviews, the The raw documentation underlying every conclusion the report drew had been destroyed before the trial. Wilkes' written opinion called that report sanitized and, therefore, less credible. He also dismissed, explicitly and on the record, the pillar on which Allen's entire defense rested, the claim that Farrow had coached or fabricated Dillon's account out of revenge. Wilkes found no credible evidence for that theory. He criticized Farrow separately for videotaping Dillon's initial account in a way he found unhelpful to the subsequent investigation, but on the fabrication argument, he was direct. It was not supported by the evidence before him. The ruling that a generation of retrospectives summarizes as he was never charged, never convicted contains, on page 19, a judge's written finding that a man's behavior toward a 7-year-old child was grossly inappropriate and required protective intervention. That sentence has been sitting in a public archive for over 30 years. I'll be honest about something. I went into this document expecting it to give me clarity, expecting that reading the actual ruling, instead of the summaries of it, would produce some kind of certainty. It didn't. What I found was a judge doing something genuinely difficult, holding two things in the same sentence that don't normally live together. I cannot find that abuse occurred, and this man's behavior toward this child requires protective measures. I've come to think the discomfort in that construction is not a failure of legal reasoning. It might be the most honest thing in the entire record, a formal acknowledgement that the truth here resists the clean containers the law is built to provide. If this kind of document-first approach to history is useful to you, subscribing keeps this channel going. Full source list in the description. Back to the record. The custody ruling was a civil matter. Running alongside it, in a different jurisdiction, was a criminal track. On September 24, 1993, Litchfield County State's Attorney Frank Mocco held a press conference in Connecticut. He announced that he had found probable cause to believe that a crime had been committed. He also announced that he would not prosecute, citing the toll that a criminal trial would exact on the child at the center of it, and the legal uncertainty of the outcome. One wire service story that ran in newspapers across the country the following morning summarized Mocco's position plainly. Woody Allen probably did sexually abuse Dillon Farrow, but would not face charges. Allen's legal team responded with a lengthy statement maintaining his innocence. He subsequently filed a formal misconduct complaint against Mocco with Connecticut's disciplinary review authorities. After approximately 5 years of review, that complaint was dismissed. No disciplinary action was taken against Mocco. In the shorthand that attached to this story and has persisted since, he was never charged. The word never carries a weight it doesn't quite support. A never charged finding can mean no evidence. It can also mean a prosecutor who said he believed the act probably occurred, and who declined to proceed because he was unwilling to put an 8-year-old through a trial he considered emotionally unjustifiable. In this case, the public record specifies which kind of never charged this was. The prosecutor said so himself at a press conference in September 1993. Both things are true simultaneously. No trial was held, and a sworn law enforcement official stated publicly that he believed the act had probably taken place. Allen appealed Wilkes' ruling in January 1994. The Appellate Division of the New York Supreme Court heard the case and issued findings that neither fully vindicated nor fully condemned either party. On the abuse allegation itself, the appellate judges used language softer than Wilkes, calling the supporting evidence inconclusive rather than grossly inappropriate. But on the question that had anchored Allen's defense, the fabrication theory, the claim that Mia Farrow had constructed the allegation from scratch in a state of revenge, the appellate panel reached the same conclusion Wilkes had. The record, they found, did not support it. They also criticized the Yale New Haven report directly, noting it had failed to account for Dillon's documented pattern of offering inconsistent accounts of distressing events. A report built on months of interviews, produced by a team that destroyed its own underlying notes and whose lead clinician never appeared in open court, remained, even at the appellate level, a contested document. From the civil and criminal record, One physical piece of evidence belongs beside the two court rulings. During the Connecticut investigation, state police searched the attic crawl space where the alleged incident was said to have occurred. They collected hair fibers. The state's forensic chief, Dr. Henry Lee, one of the most credentialed forensic scientists in the country at that time, examined those fibers and concluded they could not be used to place Allen specifically in that space. Separately, during a 3-hour interview with Connecticut police, investigators told Allen they had found fingerprints in the crawl space. Allen's initial response, according to the interview record, was that he had never been up there. He later modified that statement, conceding the prints might be his after all. 3 institutions producing 3 kinds of record. None of them aligns into a single clean verdict. A trial judge who found the behavior grossly inappropriate without concluding abuse. An appeals court calling the evidence inconclusive while rejecting the fabrication theory. A forensic examination that collected physical evidence in the room but could not tie it to one person. This is not ambiguity produced by missing evidence. It is ambiguity produced by evidence that points in directions the law was not built to resolve. For approximately 20 years after the custody trial, Dylan Farrow did not address the specifics publicly. That changed on February 1, 2014. She published an open letter on the blog of New York Times columnist Nicholas Kristof, who described it in his own framing note as the first time she had spoken directly and in her own words to the public. She was by then 28 years old. She wrote about being 7. Being led by Allen into an attic she described as dim and closet-like. Being told to lie on her stomach and play with her brother's electric train set. She described the incident as framed, in the moment, by Allen, as a secret between them. She described the years that followed, an eating disorder, episodes of self-harm, sustained difficulty trusting people. She described the specific, recurring pain of watching Allen receive professional honors, standing ovations, lifetime achievement awards, industry tributes, while she carried what she says happened to her. The letter closed by addressing actors who had worked with Allen in the years since and asking them, by name, to hold in their minds the image of their own 7-year-old daughter. Allen's publicist called the account untrue and disgraceful on the day of publication. Allen subsequently published his own op-ed in the Times, restating his denial and citing the investigations that produced no criminal charges. In December 2017, as the Harvey Weinstein reporting reshaped how the industry discussed sexual abuse by powerful men, Dylan published again a piece in the Los Angeles Times asking explicitly why the same reckoning had not extended to the man she says abused her. The following month she spoke on CBS This Morning to journalist Gayle King, repeating the core account for a national television audience. By November 2017, protesters at a women's rally in Oviedo, Spain, had hung a banner bearing her allegation around the neck of a bronze statue of Allen erected in the city years earlier. A local women's organization subsequently petitioned for the statue's removal. Whether Dylan Farrow's account is accurate remains, factually, a disputed and unresolved question more than 30 years after the events she describes. What the record does show is that the specific details at the center of her account, the attic, the train set, the framing as a secret, have held consistent shape across every version she has given. Her statements to investigators in 1992, the custody trial record of 1993, her 2014 open letter, her 2017 op-ed, and her 2018 television interview. In May 2018, Moses Farrow published a lengthy personal statement on his own website under the title A Son Speaks Out. Moses, adopted by both Mia Farrow and Andre Previn, and formally adopted by Allen as well, wrote that he had been present in the Connecticut house on the day of the alleged incident. He wrote that the layout and supervision of the household that day made it impossible for Dylan to have been alone with Allen. He wrote that the allegation, in his assessment, did not occur. He described his own public condemnation of Allen in 1992 as the action he most regretted in his life, something he said he did to secure his mother's approval. He made a further claim. that Mia Farrow had been physically and emotionally abusive toward him and multiple siblings throughout their shared childhood, describing specific incidents involving his late brother Thaddeus and his sister Suni. He challenged the testimony of nanny Allison Strickland directly, asking why she had not immediately reported what she said she saw to the other nanny in the house that afternoon. Dillon responded publicly the same day Moses published, calling his account an attempt to deflect from a credible allegation and noting that his characterization of her mother contradicted years of his own prior statements. The two have not spoken publicly in a constructive capacity since. Moses also raised, in his post, a fact that exists independent of his own credibility and is verifiable through a different state's court records entirely. Mia Farrow's brother, John Charles Villiers Farrow, was prosecuted in Maryland in 2012 for sexually abusing two boys over approximately 6 years. In 2013, he entered a null-forward plea, a plea acknowledging that prosecutors possessed sufficient evidence to convict, without constituting a formal admission of guilt, to 2 counts of child sexual abuse. He was sentenced to 10 years in prison. A separate case. A different decade. Different victims. No documented evidentiary link to the allegation against Allen in the Connecticut attic. Moses presented it as evidence of a broader pattern of dysfunction in the Farrow family that, in his view, outside accounts of this story had consistently overlooked. What 2 adopted children of the same household, both present by their own accounts during the same childhood, have given the public are 2 complete and mutually exclusive accounts of the same years, the same house, and the same parents. Both cannot be the full truth. 3 months before Moses published his account, in September 2018, Suni Pravin gave her first extensive public interview. She spoke to New York Magazine writer Daphne Merkin, who has herself acknowledged a decades-long personal friendship with Woody Allen. Suni, adopted by Farrow and her former husband Andre Pravin from South Korea as a young child, and now married to Allen, described her upbringing in the Farrow household as one she remembered without warmth. She recalled physical discipline. She recalled being held upside down as a child because, in her account, Farrow believed the blood rushing to her head might improve her cognitive function. She said that when asked to identify a single pleasant memory from her years in that household, she found she could not. She described feeling less like a daughter than like household staff, responsible for cleaning bathrooms and, once Allen began visiting the Connecticut property, for pressing the bed linens. She described the moment her mother discovered the Polaroid photographs, a brief phone call in which Farrow said only her name. Pravin has separately acknowledged, in the interview and elsewhere, that the affair caused Farrow genuine and serious harm. She has maintained that her marriage to Allen, which had lasted more than 2 decades by the time she spoke to the magazine, was never an act of revenge. A spokesperson for the Farrow family disputed Pravin's specific accounts of physical discipline and differential treatment in a statement to New York Magazine. Dylan Farrow noted on social media that week that the article made no mention of the Connecticut prosecutor's probable cause statement. Ronan Farrow called the piece a hit on his family. What the record shows, independent of which version anyone accepts, Mia Farrow's adopted daughter has now given the public an account of her mother that is, in its detail and in its seriousness, fully comparable to what her sister gave about Allen. 2 daughters. 1 house. 2 completely opposite answers to the question of which parent required protecting against. Ronan Farrow, the only biological child Mia Farrow and Woody Allen had together, born Satchel in 1987, became, by his late 20s, one of the country's most consequential investigative journalists. In 2018, he shared a Pulitzer Prize for reporting that contributed substantially to the public accounting of Harvey Weinstein's conduct and accelerated the national conversation that became the #MeToo movement. When Moses published his 2018 statement, Ronan answered within the day, calling it a campaign to discredit his sister and stating that no sibling he had spoken with had experienced anything from their mother but care. Moses had anticipated that framing in his original post. He wrote that family members had been offered financial inducements to align publicly against their mother, and that he personally had refused an offer involving his college tuition. That claim has not been independently verified. In March 2020, the Rift moved into a publishing house. Hachette Book Group had contracted to publish Woody Allen's memoir, Apropos of Nothing. Ronan Farrow's own book, Catch and Kill, about powerful men who evade accountability for sexual abuse, was published under a Hachette imprint. When the Allen acquisition became public, Ronan said the company had concealed the decision from him, severed his relationship with the publisher, and said so publicly. The following day, approximately 75 Hachette employees walked out of the company's New York office and gathered in Rockefeller Plaza. Within 24 hours, Hachette had dropped the Allen book and returned his rights. Allen found another publisher and released the memoir weeks later. Author Stephen King objected publicly to the cancellation on free expression grounds. Dylan Farrow described the walkout as the first time in her adult life that people outside her immediate family had treated what she says happened to her as something that mattered. By 2018 and into 2020, the family that the press had always treated as a single unit with a single set of facts had divided into two camps with two irreconcilable histories. Dylan, Ronan, and Mia. Allen is the abuser, Mia is the parent who protected. Moses and Suni. Allen is falsely accused, Mia is the parent who should have been scrutinized. Dylan has said her brother Moses is dead to her. Moses has said he would be willing to take Allen's surname legally. No reconciliation between the two camps has been reported. I keep returning to the four of them as children, Dylan, Ronan, Moses, Suni, in the same rooms, probably fighting over the television, eating dinner at the same table. Then, 30 years later, each one choosing a different parent to anchor to. I don't think that kind of fracture happens because someone is simply inventing a story. I think it happens because surviving certain kinds of childhood sometimes requires deciding, with whatever clarity you can manage, which account of what happened you can live inside. Which of them got it right is not something anyone outside that house will ever be able to determine with certainty. What I'm sure of is that none of them has gotten to leave it. They are all four of them still in there. One more document. Not from the custody case. Not from the criminal investigation. From the other man in this story and from the very end of his life. May 1998. Beverly Hills. Frank Sinatra's funeral. Mia Farrow attended with her son Ronan. She sat alongside Nancy Sinatra, the daughter, and Nancy Sinatra Sr., who had been Sinatra's first wife. 3 women with 3 different histories with the same man, gathered in the same room at the end. In a 2013 interview with Vanity Fair, Farrow described what she placed inside Sinatra's casket before it was closed. A small bottle of Jack Daniel's whiskey. A dime, the kind of dime Sinatra had always told people to keep on them in case they ever needed to reach someone. A piece of his philosophy about readiness, about staying connected, small enough to carry in a pocket. And her wedding ring. The ring from the 5-minute ceremony at the Sands Hotel in 1966. The ring from the marriage that ended on a New York soundstage, delivered by an attorney while she was still in costume, while 1 month of filming on Rosemary's Baby remained. She had kept that ring for 32 years. Through the divorce papers, through her marriage to Andre Previn, through 12 years with Woody Allen, through the photographs on the mantelpiece, the allegation, the custody trial, the prosecutor's press conference, the appellate ruling, and everything that followed. Through all of it, she kept the ring. And then, in May 1998, she put it inside a casket. She has said in other interviews that she never entirely accepted the legal ending as the real one. That whatever the formal record claimed, the connection between them continued differently, changed in form, but not dissolved. Through everything. Until it stopped because he died. The Vanity Fair interviewer asked her directly, had Frank Sinatra been the great love of her life? Her answer, on the record, in print, attributed to her by name, was one word. Yes. The woman the press spent 60 years describing as an ingenue swept into a legend's orbit, then a muse standing in a genius's light, then a scorned wife who reached for the worst accusation she could find, put her wedding ring in a dead man's casket 32 years after he sent a lawyer to end the marriage she'd refused to walk away from, and said the word yes to the question of whether he was the love of her life. That is not the story anyone told about Mia Farrow. It is the one she left in the record. And the record, as it turns out, was there the whole time.